We now come to part 5 of the code, and this deals with the miscellaneous segments of the code. So it starts with 224, which is Insolvency and Bankruptcy Fund. We read earlier in Accounts and Audit that the government shall put its grant into this Insolvency and Bankruptcy Fund. No, I'm sorry, that is the fund of the IBBI. This is the Insolvency and Bankruptcy Fund. Okay? For the purposes of insolvency resolution, liquidation and bankruptcy of persons under this code, there shall be credited to the funds the following amount: grant, amount deposited by a person as contribution to the fund, amount received by the fund from any other source, interest or other income. So it's grants, contributions, others and interest. A person who has contributed any amount to the fund may, in the event of proceedings initiated in respect of such person under this code before an AA, make an application to the AA for withdrawal of funds not exceeding the amount contributed by it. So if a person has made a contribution, he can make a request for withdrawal of up to that contribution, but only for specified purposes, namely payments to workmen, protection of assets of such person, meeting incidental costs during the proceedings or such other purposes as may be prescribed. The central government can appoint an administrator, shall by notification appoint an administrator to administer the fund in such manner as may be prescribed. Power of the central government to issue directions. Without prejudice to the foregoing provisions of the code, the board shall, in exercise of its powers of the performance of its functions, be bound by the regulations, directions on questions of policy as provided by the central government. So central government only has the power to make directions on questions of policy, provided that the board shall, as far as practicable, be given an opportunity of being heard on the subject. The decision as to whether a particular aspect is one of policy or not, question on whether, see here the government has the right to make directions on policy matters, but what is a policy or not is at the discretion of the government. Power of the central government to supersede the board. If at any time the central government is of the opinion that on account of a grave emergency the board is unable to discharge its functions and duties, or so there's a grave emergency, or the board has not complied with any direction issued by the central government under this code, or in the discharge of the functions under this code, and as a result of non-compliance, the financial position of the board has deteriorated. So that's the second condition. There's a deterioration in financial conditions of the board because of certain reasons specified in this section. 3. Circumstances exist which in public interest makes it necessary to do so. The central government in these above circumstances, which are 3 circumstances, grave financial situation, and third is public interest, it can supersede the board for a period not exceeding 6 months. So you may want to star this. So supersession, if any, by the central government can only be for a period of 6 months. Upon publication of a notification under section 1, subsection 1. So in order to be able to supersede, the government has to first issue a notification. Upon the publication of a notification under subsection 1 superseding the board, all members of the board shall vacate office. All powers, functions and duties which were available to the board under this code shall be exercised or discharged by or on behalf of the board until the board is reconstituted. 3. It shall be discharged by the persons as directed by the central government. So first is the members of the board shall be deemed to have vacated office. Second, the powers which were vested in the board will be vested with the persons whom the central government thinks fit and direct. 3. All property owned or controlled by the board will vest with the central government. That's about it. So 3 things happen. Okay, one is powers and functions. The board gets vacated. Two, powers and functions will go to such people as the government thinks. And the third thing is the property stands vested with the central government. Power of the central government to notify financial services providers. Notwithstanding anything to the contrary examined in the code or in any other law, the central government, if it considers necessary, with the appropriate financial sector regulators, notify financial service providers or categories of financial services providers for the purpose of their insolvency and liquidation proceedings, which may be conducted under this code in such manner as may be prescribed. So it basically says the central government can notify financial service providers. But elsewhere, I'll talk about it when I'm doing the corporate part, is it also says in section that a financial services regulator cannot come under this code. I'll come back to you on this section, but here they have given the option to the central government to notify certain financial services providers who can come for the purpose of their insolvency and liquidation under this code. Budget. The board shall prepare in such form and at such time in each financial year as may be prescribed its budget for the next financial year, showing the estimated receipts and expenditure. Just give me a minute. Okay, so we then go to the annual report. The board shall prepare in such form and at such time in each financial year as may be prescribed its annual report, giving a full account of its activities for the previous financial year. So first of all, they have to make a budget for the next financial year. Now they have to give an annual report for that financial year annual report in a financial year of the summary of activities of the previous financial year, and submit a copy of the report thereof to the central government. Incidentally, if you recollect, in the earlier one we had read that even the annual financial statements, which is audited by C&AG or any other person appointed by C&AG, shall be placed before both the houses of the parliament within 30 days. Here the annual report shall also be placed before each house of parliament. Delegation. The board may, by general or special order in writing, delegate to any member of or officer of the board such of its powers or functions as may be deemed necessary. Bar of jurisdiction. No civil court shall have jurisdiction in respect of any matter in which the AA, the NCLT or the DRT or DRAT or NCLAT is empowered under this code to pass an order, and no injunction shall be granted by any court or any authority in pursuance of an order passed by an adjudicating authority under this code. So the same thing is there in the relevant sections or segments also, which deal with individuals and corporates. Members, officers and employees of the board to be public servants. So members, employees and officers of the board shall be public servants within the meaning of the Indian Penal Code. Prosecution of action taken in good faith. No suit, prosecution or legal proceeding shall lie against the government, officer of the government, chairperson, member, officer or employee of the board, or an insolvency professional, or liquidator, okay, for anything which is done or intended to be done in good faith under this code or the rules and regulations made thereunder. 234, so basically it says there is a protection for acts done in good faith. Then we go to 234, agreements with foreign countries. The central government may enter into an agreement with the government of any country outside India for the purpose of enforcing this code. So it basically says that the government can enter into agreements with other foreign governments. The central government may, by notification in the official gazette, direct that the application of the provisions of this code in relation to the assets or property of a corporate debtor or debtor, including a personal guarantor of such corporate debtor or debtor, as the case may be, situated at any place outside India with which reciprocal arrangements have to be done, shall be subject to such conditions as may be prescribed. So what is it basically? You remember that during this insolvency resolution process and even much later, the assets are held abroad, in which case they anyway belong to the corporate debtor or the debtor. Now, application of the provisions of this code in relation to foreign assets shall be subject to such conditions as may be specified. So that's what it says. It says you can enter into reciprocal arrangements, and how you handle the foreign assets of a corporate debtor or a debtor who's come under this code will be subject to as the prescriptions under this code. 235, letter of request to a country outside India. Notwithstanding anything contained in the code or any other law for the time being in force, if during the course of the insolvency resolution process or liquidation or bankruptcy proceedings as the case may be, the RP, liquidator or the bankruptcy trustee is of the opinion that the assets of the corporate debtor or including a personal guarantor of the corporate debtor are situated in a country outside India for which reciprocal arrangements exist under the previous section, then he may make an application to the adjudicating authority that evidence or action relating to such assets is required under the proceeding. So first of all, there is a reciprocal arrangement, and then there are assets outside India. So the person in the middle, who is the IP, IRP, RP, liquidator, bankruptcy trustee, he shall apply to the adjudicating authority stating that he needs evidence or action in relation to the assets which are being held abroad. So he has to make an application first. So he can't just go ahead. The adjudicating authority, on receipt of an application and on being satisfied that he needs to initiate evidence or action, then he will issue a letter of request to a court or authority of such country competent to handle such a request. So the last two things were important. One, I need to have a reciprocal arrangement. I need to have an asset which is abroad. I need to have evidence or action in respect of such asset for my insolvency resolution process. It can be assets of the corporate debtor or the personal guarantor of the corporate debtor, in which case as an RP I have to apply to the adjudicating authority saying I need help, I need evidence, action, based on which the adjudicating authority will now send a request. It will issue what is called as a letter of request, is what the code says, to a court or an authority of such country competent to deal with such request. With this, we conclude up to one part of part 5, which is up to section 235. In the next, we will go through the power to make rules, regulations, the constitution of special courts, appeals revisions, and the non-obstante or the provision to override other laws which is contained in the code.